Thank you everybody and welcome back to my channel. Today we're going to talk about something that's very important to me as a realtor because I always look out for my clients. And when I see clients go through the probate process, sometimes it's heartaching because they lose a lot of money, which money they can't afford to lose. So I'm here with Larissa Drohobyczer, Larissa Law. She's an attorney here, a very good one in Las Vegas. So we're going to talk about the probate process and trusts, because that's a big one. I recommend everybody get a trust, and we'll talk about that and we'll talk about why. Tell me a little bit about yourself and your practice.
So as you mentioned, my name's Larissa. I'm an attorney here in Las Vegas, Nevada. I've been an attorney since 2012. And my practice is probate, estate planning, and personal injury. And I've helped many clients in Las Vegas with the probate process and helped a lot of realtors like Shane with real estate transactions in the probate process.
What is probate? Can you tell me what that is?
Sure. So probate is actually a court process that is started when a person dies, when they have assets solely in their name. So if somebody passes away and their name is on all their assets without a co-owner or beneficiary, then probate's going to be required to pass those assets along to living people. And so court is required because the judge has to sign off on transferring those assets.
Yeah, so they usually just contact the closest living relative, right?
So what happens is normally a relative will contact an attorney to start that probate process. And what's going to be needed is a death certificate and a will if the deceased person left a will.
And if they don't have a will?
If they don't have a will, unfortunately, the assets are going to pass according to the state law. So the government has come up with a plan for how assets are going to pass if a person does not leave a will or a trust.
And that can get pretty complicated and ugly, right?
It can, because a lot of times the government's plan is not the plan that the deceased person would have wanted.
Yeah.
So if you want to leave all your assets to your girlfriend or a family member, but they're not in your will, the government plan may override what your plan was if you didn't properly put it in a will or a trust.
Yeah, and then if you have a lot of kids or a lot of siblings, they start to fight and bicker over who gets what.
Yes, and that conflict can be very costly.
Yeah, it is. So the probate process is a long process when it goes through probate because it goes through the courts.
Correct.
And sometimes those courts get backed up. Like we saw during COVID, it was a whole fiasco, it was a whole mess. It still takes a while. Can you go through step by step what that probate process looks like? So an heir will contact you. What does that probate process look like when it starts from there?
So when probate process gets started, the court accepts a petition that is basically paperwork that we start and we send to court to say that this person has passed away, they left these assets, these heirs, and if they left a will or not. And after that, there's going to be a period where creditors are notified regarding the deceased person, so creditors can come forward and claim assets of the deceased person. Then what's going to be required is going to be an inventory of all the assets and other reports that are required for court. And in Nevada, the normal probate process can range anywhere from 4 months to about 18 months, depending on the size of the estate.
Just that first process, correct?
Correct.
Yeah, so before it even gets to me as a realtor, if you're going through the probate process, you got 4 to 18 months possibly just to sell that property and get that money.
Yeah, and once the property is sold, it doesn't automatically go to the heirs. It still has to go through the court process to be released.
Yes, it does. So after it comes to me, what happens is we'll list it, we'll get somebody who puts an offer on it, we'll get a price on it, and then it goes back to the courts before it can sell to make sure nobody comes in and overbids on that property, correct?
Yes.
Yeah, and that can take anywhere from, I've experienced it from 6 weeks to 8 to 12 weeks.
Yeah, that's correct.
Yeah. And then sometimes someone will come in and it'll suck for the buyer who put the bid on it and won that contract, because somebody might come in because it has to go through court again, and someone might come in and overbid on that home. And that's also kind of scary for the person selling it too, right?
Yeah, it's very intimidating for people to have to go through probate or to sell real estate in the probate process. So one thing that will alleviate a lot of that court process and costs would be getting a trust.
So if they don't have a will, they have to go through the government to say how those assets are being distributed.
Correct. So the government meaning the state legislature has already come up with a plan for how assets are going to pass to a deceased person's heirs if they don't leave a will. And it doesn't matter if the deceased person ever spoke to that person or liked them. If there's no will, it's pretty solid plan that the government has for how the assets are going to pass.
So how does that plan work?
It'll go to the next of kin. So normally the surviving spouse and or living children. And if there's no spouse or children, it will go to parents or siblings.
Okay. So right there, all that explained, probate in itself, the government's hands in it. And anybody knows when the government's hands in it, you're pretty much losing money, because I often run times to people going through probate and the home is a disaster. So they have to sell it as is and they don't have the funds to bring it up to market value. And they lose a lot of money because sometimes you can put a little money in it and get a lot more out of your home if you put it up to date, which I've done before. And then I've also had to sell as is and they get as is prices.
I've definitely seen that myself.
Yeah, plenty of times. And then I've also been on the buyer's end where we have to wait for the courts to go through. The sale went through. It went through the final process where nobody overbid. And we had to wait a month for the judge just to sign the sign off for that deal to go through.
Yeah, there's definitely built-in delays into the court process and probate. So as I mentioned, the best alternative would be getting a trust.
Okay.
And that would expedite the sale of the property and it would keep the courts out of your business and out of the sale.
Yeah. So how does one create a trust? What is a trust?
So what a trust is basically it's a legal concept where an individual will create an agreement and they will decide who's going to manage their assets when they pass away or become incapacitated. And also they will name who's going to be in charge of distributing those assets. So that's going to be an agreement that's set up in paperwork. You should do that with an attorney, but there are online platforms that those trusts can be created with. And the most important thing that needs to be done when you create your trust is actually aligning your assets to the trust and funding your assets into that trust. So if you have real estate, that would be creating a deed where you're going to deed your property over to your trust and make your trust the owner of the property.
Yes, and that's a very smart thing to do, correct? Because
yes.
It keeps the government out.
It makes it more private. It makes it more efficient, cost effective. Pretty much anybody who owns real estate should have a trust.
Yeah. And then how you get a trust is I recommend you call an attorney like Larissa here and get a trust, because there's many ways to form a trust. Say you got 2 kids and one kid's irresponsible, but you want to get some of it. So you want to keep the responsible kid to, distribute those funds correctly, right? So there's many ways. Or if you have a child with special needs or something, and you want to make sure they're looked after, you can structure that trust in many different ways.
Right. So the trusts are fully customizable, and working with an attorney is going to be the best option because you're going to make sure that your wishes are carried out properly. I've unfortunately seen a lot of disasters where people have done their own trusts online and it's costed about 5 times more than what it would have costed to get it done properly just to clean up that mess.
Yeah, I bet. So how much do you think somebody that doesn't have a trust and has a trust, how much do you think that probate process costs a family if they go through probate?
So there's actually a formula that we've calculated that probate normally costs between 2 to 5% of the estate. So if you leave $200,000 worth of assets, 2 to 5% would be $4,000 to $10,000. And getting a trust is a fraction of that. A lot of trusts will start at around $2,500 and they go up from there depending on the complexity. But you not only get the trust, you get your full estate plan with that price, meaning your power of attorney, your healthcare directive, your HIPAA, and all the documents you'll need if you become incapacitated or pass away.
Okay. And that's not even including the time. I mean, time is money, and the year it takes to go through probate.
Correct. So with a trust, access to those assets are immediate. Unlike the probate process where it has to go through court and a judge has to sign off on things, if you have a trust, the trustee, who's the next person in line to take care of the assets, will be able to access those immediately and dispose of them as,
as they wish. That is great. So get a trust, people, please. If you don't know me yet, my name is Shane Judge. I'm a real estate advisor, helping people like you relocate, buy, and sell and invest in real estate. And the reason I do these videos with professionals like Larissa here, because I do care about my clients and I want to make sure their wealth is secure, and I help build wealth. So I will make sure that wealth I help build through real estate is secure. So if you're still here, please like this, subscribe, smash that notification bell, because I'll do more educational videos like this about real estate. So when you get involved with it, you have every aspect covered. So a lot of people will do a will, right? So what's the difference between a will and a trust, and which one's better? Because a will still goes through probate process, correct?
Correct. So a will is a written document that will state where you want your assets to be distributed when you pass away and name an executor who's going to be in charge of distributing those assets. But a will is going to have to go through probate if there is a probatable estate. And a probatable estate is going to be anything that's left solely in the decedent's name without a co-owner or beneficiary. So if there's a home with a co-owner on it and the co-owner is living, there will be no probate because it will just be a joint tenant and the property will pass by operation of law. But if their asset, as I mentioned, is solely in the deceased person's name, there will be a probate, and that will go through probate, and it's public. And a trust is basically like a will, but it's a will substitute. It's a private agreement where you transfer your assets to the trust and you name a successor trustee to manage them when you become incapacitated or pass away. So it does not go through probate because it's a private agreement and you've transferred your assets to a trust. So you can kind of think of a trust like an LLC, but it's not for necessarily business purposes.
Gotcha.
So you transfer your assets, you name a successor trustee, and they step into your shoes and manage the assets when you become incapacitated or pass away.
So obviously trust is much better than the will because the will still has to go through probate. So it's just naming your successor. And if you have your wife living with you and you want to give it to your kid, it's going to go to your wife anyways.
If you do not have a will. So since Nevada is a special state called a community property state, where spouses have special interests in property. So sometimes what happens is if you have a spouse and you decide to leave certain property to a non-spouse, if your spouse is living, they can still have rights in that property and supersede your trust or your will. But that's just in a community property state like Nevada and a few others in the US. Most states are not like that. But Nevada is unique in that sense.
Yeah. So definitely call a lawyer, get a trust, and make sure you know everything about where your assets are going if you happen to pass away. So it leaves your family feeling secure and not having them go through the horrible thing that is probate.
Yeah, not only that, a lot of people don't talk about incapacity. So with people living longer, more and more people become incapacitated, and that's when they cannot manage their affairs due to mental or physical disability. And having a trust will also protect against incapacity.
Yeah, that's a good point. So recently I've gone through this, and it's very difficult to bring up somebody dying, right? People get uncomfortable about it. People get defensive. My aunt and my cousin were in this situation where, he's just looking out for the best for their family. And he brought it up to her and she got offensive. What do you think would be the best way to bring up something like this to a loved one?
Right. Yeah. So talking about death and money are both taboo, but death especially is a very sensitive topic for people, but it's one of the guarantees in life. Unfortunately, anybody living is going to pass away. So it is very important to bring the conversation up with compassion and care. And instead of making it an absolute, like when you die, it's very important to be sensitive to a person's feelings about death and say, in the event that something were to happen to you, do you have a plan? Making it more so a conversation about planning instead of dying. Yeah. And, dotting your I's and crossing your T's is the best way that I've seen clients have the conversation about death. Because I've been in this industry for so long, I'm pretty much fine with that part of life, passing away. But it's a very difficult topic for people to discuss, but it's very important because if you pass away with no plan, it's going to leave your assets and your family in shambles, and it will cause a lot of conflict.
Yes.
And it can cost a lot of money.
Yeah. Okay. So pretty much just planning.
Yeah, bring it up as, do you have a plan if this were to happen?
Yeah.
We plan vacations, we plan for retirement, we plan for a lot of things, but unfortunately we don't plan for an absolute, which is passing away.
No, because somebody wants to talk about it.
Yeah.
I get that. And I think maybe one way to do that is lead by example. Be like, hey, this is my plan in case something happens to me. Do we have a plan for us yet or you yet, maybe? So bringing it up is very touchy subject. When do you think somebody should start planning for this? For me as a realtor, as soon as somebody purchases the property, I always recommend them or advise them to open up a trust? Because tomorrow's not promised for anybody. So when do you think people should start planning for this situation, like a trust?
So estate planning really can be done once a person is over the age of 18. Planning will not necessarily bring about the event. So unfortunately, there is no age for death. You can die at a very young age from an accident or illness. And anybody over the age of 18 should have a plan, and your plan will be good for the rest of your life, and you're able to make updates. So I do recommend that anybody with anything that they care about or anybody that they care about have a plan, not necessarily for their assets per se, but also for their family members. If you're a parent, you should have an estate plan about where your money's going to go and how your children will be cared for and who will care for them. Typically, the age that most people start planning is around their 30s and 40s. It's become a lot younger with COVID. Before, clients were a lot older. They'd be in their 60s and 70s. But since COVID happened, I've had a lot of clients in their mid-30s to 40s and 50s start planning.
Okay. So let's say we make a plan early. You can change this trust formation anytime, right?
Oh, yes. So as long as you have what's called a revocable trust, it can be updated or changed any time in your life as long as you're not incapacitated. And a will is the same thing. You can update those documents at any time throughout your life as long as you have the wherewithal and the mental capacity to update them. So my recommendation would be start a plan sooner rather than later. And as your life changes, then you update your plan.
Yeah. Is there a cost associated with those updates? Probably
So there's very minimal costs associated with updating your estate plan. They will be very minimal in comparison to what court would require or hiring an attorney after the fact. So, it's better to plan things ahead of time and have a good plan in place, especially if you have assets and minor children.
Okay. So how can they get a hold of you to start the estate plan? I'll leave all her contact information in the description below if you're watching this.
So if anybody has questions about estate planning or general legal questions, they can contact me at 702-999-4444. And my website is larissa@law.com, larissa@law.com. But the number is the best way to get a hold of me, 702-999-4444.
And she does respond. Larissa, thank you for coming and educating these viewers so much. I hope they reach out to you. I appreciate it greatly.
Thank you so much.